The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. Welcome, counsel, and to those watching on our Supreme Court Live channel. I will now ask Mr. Doug Shima, the clerk of the appellate courts, to please call the morning docket.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Thursday, April 1st, 2021 consists of one case. Appeal number 121715, State of Kansas versus Heidi L. Hillard, Sedgwick County, briefs both sides. The appellant has reserved 2 minutes rebuttal time. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
May it please the court, my name is Reed Nelson, and I am appellant Heidi Hillard, and I am present here and ready for argument.
May it please the court, Assistant District Attorney Lance Gillette, on behalf of the state of Kansas, present and ready for argument.
Thank you, counsel. Mr. Nelson, you may begin your argument.
Thank you, Your Honor, and just very briefly to summarize what the case is about. The crimes here occurred in rural Sedgwick County, and Ms. Hillard, my client, was charged and convicted with a number of high-level felony crimes, including premeditated murder, felony murder, aggravated kidnapping, aggravated battery, and I will discuss some of those during the argument. I'll turn initially to our issue number one from the brief, and that's where the trial court limited the cross-examination of one of the two state's eyewitnesses, Samantha, on the possible charges that she avoided by testifying for the prosecution. And this violated Hillard's Sixth Amendment right to confront and cross-examine her.
Counsel, could you please walk me through your best argument on how the defendant Heidi preserved the evidentiary basis for those Sixth Amendment claims?
Yes, Your Honor. We concede that Ms. Hillard's attorney did not join in the objection. Mr. Sievert represented Mr. Hillard, and he is the one who really did the heavy lifting on the objection. And in this particular instance, Ms. Hillard's counsel did not happen to join when he did that. However, number one, Ms. Hillard referenced this in the motion for new trial, indicating that indeed she did want to cross-examine on this. And number two, I would point out that this is a little bit unusual because these two defendants were very aligned at trial. These were not antagonistic defenses. Furthermore, the main thing on this type of error, which I think is quite important to the trial, having to do with this confrontation of the witness's very motives, the main thing is for the court to have a chance to rule on a contemporaneous objection. And there was a very thorough contemporaneous objection by co-counsels or by the co-defendant's lawyer.
Mr. Nelson, typically in trials that are jointly tried together, co-counsel will share in the objection. I join the objection. Did that happen in most instances in this case, or do you know? It was just kind of just an oversight by counsel not to join, or can we discern that that was something counsel did not want to join?
I can only give you my general impression from the trial, which is that generally Mr. Brown did join with Mr. Siebert. Yes, I do feel as though Mr. Siebert did most of the heavy lifting in terms of legal objections, argument, analysis. I believe generally Mr. Brown joined in. Yeah, so, and I would point out also, Justice Wilson, that Mr. Brown specifically did join in with when the court denied their ability to explore the sentencing of the two eyewitnesses, what they faced as a possible sentence. It all indicates to me that Mr. Brown, that it was his desire that this be brought out, that the witnesses' motives be brought out.
But you also would concede that Heidi Hillard's counsel understood the concept and the need to join objections if that was his position.
Well, as a general thing, I would think that counsel would know that the best practice is to join the objections. Yes. Justice Wilson, I would also point out, however, that this is quite a major limit on cross-examination. I do believe it implicates constitutional rights, fundamental constitutional rights. There was no more important witness for the prosecution against Ms. Hillard than Samantha. And
Terry, let me just going to the substance of what you're saying. You said at the beginning that the defendant was limited in exploring the fact that this witness, in exchange for her testimony, would not be charged, right?
right.
Where are you getting that fact? Upon what evidence are you getting that fact that she wasn't charged because she was testifying?
Well, where I'm getting that, and I think it goes a little bit beyond. I know the state characterizes this as that there was no agreement. I understand that. There wasn't. There was no agreement between the prosecution and Samantha about her testimony. There doesn't have to be. The Mr. Siebert, who made the objection for the defense, said that he wanted to cross-examine this witness to point out the benefits she has directly or indirectly received. And he says this young lady has been left with impressions. So.
Has been left with what? I'm sorry.
Impressions.
Right, but even then, I mean, what beyond mere speculation? I mean, couldn't it be the fact that she had these injuries where she went to the hospital and the prosecutor just never saw that as a case they could make? And so her testifying had nothing to do with whether or not she was charged?
It's so I believe, Your Honor, that it goes to her, mostly to her expectations. And so that's an excellent question. Just a second. That was an excellent question, because when she claimed that she had been raped 6 times in the vagina by a taser, she suddenly made herself a victim. And as a result, she was never charged with one tiny thing that she had done during this entire proceeding, even though she helped tie Scotty Goodpasture to the chair in the shed, even though she helped tackle him and hold him down outside the shed, even though she fetched a wagon that was used to move him to the truck, even though she fetched tape. So she did all of these things that subject her absolutely to criminal liability. Absolutely.
Unless the prosecutor thought that she was coerced, which is what her story was, that she was afraid that they were going to kill her. I mean, I'm just saying that it could just as easily be that the prosecutor just didn't have enough to charge her, feel like it could stick, and that she testified anyway, right?
Well, that's their position. And so that is certainly not the position of the defense.
But what evidence is there to support the position of the defense?
Number one, that she has a pattern, not just in this case, but in other cases, of getting herself out of trouble by falsely claiming crimes. She has a case against her where she was convicted of falsely being abducted and falsely being assaulted. So
but that came out in testimony, right?
That's right. And this was a pattern that continued, right? So even in this case, the rape that she claimed, there was a cell phone on during that entire time in the car. You do hear that she was bound because she goes, "Ow, my wrist hurt." There is nothing about six taser burns. You know, she told contradictory tales about that. She said to one nurse, "Oh, it tased my ankle." Nothing about a vagina. To the police officer, she said she was tased in her anus. Nothing about 6 tasers to her vagina. 2 different stories about Jeff Hillard doing this either from the front seat or laying on top of her. She could keep nothing straight or consistent about this. And yet, as soon as the prosecution and the detectives believed that she was a victim, believed that she had been tased, which I think that they did believe that, then suddenly now she's not charged with anything, not even her drug distribution, even though she had all of this participation. So the question is, why then does the defense not get to ask her, you were knee deep in every single aspect of this murder, of this abduction of Scotty, of tying him up, of hitting him when he was down, of kicking him when he was down, and you haven't been charged? Are you hoping that the prosecution does not charge you? And is that why you are exaggerating things about Heidi? Because she was...
I'm sorry, go ahead and finish your answer.
Because she was pivotal Samantha was pivotal in some of these things that she said against Heidi, right? Because she said, "Oh, Heidi in the shed said something about hanging Mr. Goodpasture." That was very important for the prosecution's case to show that Heidi was premeditating this, because indeed he was found hung later. And yet there's nothing about her saying that in the live transcript of the shed. And Mr. Bussert said that anything like that would have been a joke, right? It was Heidi who said, "Hey, yeah, I fetched the tape to bind his mouth outside, but it was Heidi. Heidi is the one who told me to go get it. I fetched the wagon, but Heidi told me to get the wagon." So Heidi's participation, Heidi's mental is where Samantha was very much helping out the state's case against Heidi. And the defense needed to say, "Hey, you are bending your testimony in order to avoid these incredibly serious charges that you know the prosecutor has the power to bring against you. Why can't the defense ask her those things and try to establish those things?"
Your answer,
what are you going to ask her?
Your answers and questions seem to me to highlight the need, perhaps, that there have been a proffer of what that evidence might have been. Did you have an obligation under 6405 to make that proffer?
You mean a proffer about what her cross-examination
would have been, and what the evidence would have been that you were trying to elicit?
Well, I think the points through cross-examination would be made. In other words, okay, it doesn't matter what her response is. If the defense says, "You participated in directly in all of the aspects of the crime, were you concerned that you might be, and still now, might be brought up on charges by the people sitting a few feet away from you who are assessing your testimony for if they consider that it's truthful, if they consider it advances their case. Do you have any concerns about that? And let the jury decide. She says no. It may be very difficult for a jury to believe, and if she says yes, that would be helpful for the defense as well. Your Honor, I believe I'm out of time. There are.
I cut Justice Wilson off. I think she had a question.
Okay.
About the charges, what do you think that the question would have been? What charges do you think the prosecutor might bring against you? Isn't that purely a prosecutorial decision and not a decision for any fact witness?
Yes, that is purely a prosecutorial decision. The people with the power, the people with all of the power, are sitting a few feet from the witness, assessing whether the witness's statements are consistent with what the prosecution believes they should be. All right. So to me, it is exactly the same thing in a civil case. Why can't you ask in a civil case if an eyewitness in a civil case is beholden to one of the party litigants? Let's say they owe them $100,000 debt that has not been collected on. Why can't the party litigant, the other party litigant, cross-examine them and say, you owe this party $100,000 and they haven't collected on it yet, right? I mean, that goes to their credibility. One litigant's power over the other litigant, and the currency is prison. The currency is the threat of charges. I'll end on this. As an old attorney from our office when I used to go listen to his arguments in the Sedgwick County District Court, he would tell the jury that witness was not testifying, that accomplice was not testifying here to you today out of the goodness of their heart. And that is the right to back that up.
Do you think you were prevented from asking the witness, are you testifying today because you have a hope of leniency? Were you prevented from asking that?
I believe so. I think they stayed away from that, Your Honor. I believe that they were very careful after that ruling by the court. In fact, if you read the closing arguments, there is not a single mention. They only adhered to the one thing the court allowed, which was that because she had actually admitted that she was involved in drug distribution, that they could ask her about her hope of leniency for that tiny, much smaller crime. And they adhered to that and they didn't go beyond it. I think we can be pretty sure that they would have gone well beyond that had they felt like they could have. Thank you.
Any other questions? Okay, Mr. Gillette.
May it please the court. I'll focus most of my my remarks on the first issue as well, but I would welcome any questions about the remaining issues. To begin, just briefly as a factual background to give a little bit more of an understanding what went on here is that this was a group of people basically led by Heidi Hillard and her husband in the drug world here in Sedgwick County. They had previously conducted business with Mr. Goodpaster to purchase methamphetamine. It went awry. They attempted to do so again this time. And when it went awry again, that was the end of the road for Scotty Goodpaster, who both he and SS, after being tortured for prolonged periods of time, made statements to the Hillards, and ultimately Scotty ended up dying as a result of direct action by Heidi Hillard. I will just dive straight into issue one. I would agree that cross-examination is a important constitutionally protected right. However, that right is subject to the district court's reasonable control. and particularly in limiting the scope of cross-examination, which is what's been complained of here. When faced with a limitation like that, I think that a couple of the questions that have been asked so far today, 6405 absolutely imposes upon the defendant a burden to make some kind of a proffer as to what kind of evidence there is being, I guess, excluded from the scope of cross-examination. What are you being denied? That's the only way that we can secure appropriate appellate review here. So the state's first argument on this issue is that this issue is absolutely not preserved. It simply is not. There was no timely proffer of any evidence whatsoever about any unspoken or so-called deal with SS. I will tell the court that in the pretrial ruling, I'd refer to record volume 20, page 117, where this is discussed. It is very clear. The state actually suggested to defense counsel for both sides that they make a proffer if they feel they're actually being denied something here. No proffer followed. And the state was very clear in arguing that they should make the proffer that they want, that there was in fact no deal. There was no agreement with SS in order to secure her testimony. And I think that the evidence here is pretty clear. There's a valid reason to do that. She was a victim from the moment that they stormed into the hotel until she was recovered the next morning by police hiding inside the Hillard's home. She was a victim. Did she participate in some level in the crimes and the torture of Scotty? Yes, but why? Again, she was a victim in this case. So the issue is not preserved, and this court should simply not reach it. But for the same reason, the constitutional basis that the defendant seeks to use to justify this court accepting review of the claim also falls flat. The opportunity was there. It's clear. I would also note that it was brought up that Ms. Hillard's attorney generally did join in objections that were being made by Jeff Hillard's attorney. This time he didn't. And I think that while I think the defense might want to think that this is some kind of a mistake or that he was implicitly going ahead and joining, I think there's actually a better explanation for that. And that is that there was no good faith basis to ever go into this issue. And frankly, I think that I think that Mr. Sievert knew that to some extent, but he still wanted to explore the issue because he was a zealous advocate for his client. Mr. Brown and Ms. Creer, while also zealous advocates for their client, didn't see this issue as being of any worth for cross-examination purposes.
And not just potentially that it lacked value to them, but was there a risk of prejudice too in allowing that sort of cross-examination and disclosure of potential sentences and the effect that might have had on the defendants in this case? Was that part of the district court's rationale?
Are you asking specifically about sentences in issue 2?
Yeah, I guess I was focusing more on sentences than that issue, but was that part of the rationale in the sentencing limitation?
I think that
the second issue.
Yeah, on the second issue, I think that the court's primary concern was jury confusion. There is also, there could have also been some potential for prejudice there. Although candidly, I think the prejudice probably cut both ways because it would have shown that Brian Bissart has got this deal for which he had not been sentenced, for what that's worth. And that SS, she was not only was she not charged, but there was no deal made. So it could have made the state frankly, it could have made us look arbitrary. But again, I think the better way to view that is that the prosecution viewed her as a victim. And I think that the evidence bore that out.
And then on the preservation question, in terms of whether a co-defendant can preserve an issue for another defendant on appeal, is that purely a statutory interpretation question under our contemporaneous objection rule? Is that how we approach that issue?
I think that's the first and cleanest way that it can be approached. But there's also significant case law from both this court and it's this court specifically has repeatedly said that when a party fails to provide a sufficient proffer of the substance of the evidence, appellate review is precluded because the appellate court lacks a basis to consider whether the trial court abused its discretion. So you can rely on the statute, or you can rely on your precedents in applying that statute, frankly. And I think the result is the same, no matter which way you analyze this. A final point on issue 1 that I would point out, to imply in any way that SS was not thoroughly impeached does not view the record in the same way that I think it plays out. I think that, there are pages of cross-examination of SS. In particular, there was cross-examination by Miss Hillard's attorney about whether there would have been a conversation about charges with a detective, and her statement that she was concerned about on me, and the detective told her no. That was in evidence at record volume 21, pages 205 to 206. The more extensive cross-examination by Mr. Sievert also exposed that she was charged for violating her probation that she was on. She was not charged for setting up the drug deal or for physically participating in the events of this case. And that's record volume 21, page 213. That's just a fraction of the cross-examination that was done and leveled at SS in this case. So even if this is somehow preserved, even if this is somehow preserved, even if somehow the district court abused its discretion, which there's absolutely no showing that it did, then any error on issue 1 must be deemed harmless, especially under the statutory standard that would apply. It doesn't even matter if you apply the constitutional one. There was no harm, even assuming error on issue 1. I see no further questions on issue 1. If there are, as I mentioned at the outset, if there are other issues, I would welcome questions on those.
Counsel, I have one question on issue 1. Did it come out in cross-examination that SS had previously claimed sexual battery that didn't pan out or that was not true?
Yes, that's record volume 21, page 210. As that she had had a false kidnapping case that contained allegations of sexual assault. That's what came out there.
No, I have a question about the jury instruction. I'm pulling it up right now. Where it says, where it says, or another for whose conduct he was criminally, or in this case, she was criminally responsible. Can you tell me why is that? It just seems like that's not part of PIC. And do you think, I guess I'll ask this, do you think it should be part of PIC?
Sure. Especially in cases, and it could even come in a footnote to PIC. I'd be satisfied, I think, when it comes with the caveat that has been found in many of the cases where this court has found it not, that giving that language to be appropriate, It's appropriate when the cases are complex and when there are multiple actors. And here, the district court made that finding as part of its basis for why it was going to give that additional language. I guess I would also note, just as a final point on that, is that this case, unlike some instances where there may have been some finding of error, the district court did give the full PIC instruction about aiding and abetting as well. And I think a reasonable juror would understand that the language that was added, that or for the crimes of another, is clearly a reference to that subsequent instruction. And the jury was fully and appropriately instructed on this issue, even assuming that there was some kind of an error here. I guess I would also just note that the district court did cite case law, and specifically the Burton case from the Court of Appeals, and Burr is cited within that. The state also offered Green in our brief. Again, I guess the overall summation, Justice Standridge, is that yes, I think this would be an appropriate addition to PIC in some form or fashion. Seeing no other questions, I guess at this point, I would leave off with just a brief comment on issue 8.
Mr. Gillette?
Yes.
Were you getting to issue 8?
Yes.
Okay, sorry. Go ahead. Please proceed.
Okay. I don't think that there's any merit to the defendant's claim on issue 8 here. I did receive their 609 letter speaking about the intent of a legislature when a change is made. But I think when you compare the old statute to the new, the change, if any, is actually to be more modern, more encompassing. Obviously, our endangering a child statute prohibits allowing a child to be placed in a situation where the child's life, body, or health may be endangered. This court was clear in Wettrich that we interpret terms such as health based on their common meaning. That common meaning of health, especially today, will absolutely include mental health.
So are you saying then, Mr. Gillette, that when they deleted the subsection that clearly referred to mental suffering or mental problems caused, that it was just redundant? Is that your position?
I think I would explain it this way, Justice Wilson. The old statute used the term mental distress. I don't know for sure what that means, and I know we could do definitional searches there, but that statute was from 1993. I think in 2021, we can all recognize that the strides that have been made in the fields of mental health. Mental distress, while that definition may carry one of a instantaneous or momentary distressing incident, mental health as a part of health can be far-reaching and encompassing a lifelong injury as a result of the acts of another. I think that the statute, basically the revision, came with the goal of merging subsections A and B of the old statute and clarifying that, consistent with the state's compelling interest in the well-being of its children, and particularly their protection from all forms of cruelty, neglect, degradation, or inhumanity, we're going to be broad about this, and we are going to protect children in Kansas from the acts of others that would harm them, whether that be in their lives, their bodies, or their health, and whether that be active and direct, such as in an abusive situation, or passive and indirect in others, neglectful situations.
Would you concede that as it's used now that it's ambiguous? Do you think it's ambiguous?
That health is ambiguous? No. Or the statute's ambiguous? No, I would not.
Just health as it relates to whether it's physical and mental.
But no, I wouldn't. I think that the dictionary definition that we've included in our brief is very clear. I can tell the court that even if you do the Merriam-Webster online dictionary today, it's very clear that health, the primary definition is being sound in mind, body, and spirit, or excuse me, body, mind, and spirit in that order. I don't think that definition has really changed that much. I think that, as we point out in our brief, that the Daniels opinion the defense relied on simply got it wrong. And we understand health in broad terms now.
Justice Dandridge asked the question I was going to ask you on that issue. My only other question was on issue 6. The defense cites in their 609 letter the Crosby opinion, and I was wanting to get your position on whether or not that actually resolves that issue against the state on the sufficiency on the conspiracy charge.
No, it doesn't. I think that the situation here is a little bit different than existed in Crosby, because what we had here was, and again, we're focusing on a conspiracy. So what we're talking about is not just distribution, it's conspiracy. The focus is upon the agreement. And here what we had was Heidi Hillard, in consistent pattern with her quote unquote drug family, entered into an agreement with Scotty Goodpaster that she would give him some money. He would then have to take that money, come up with some other collateral, and purchase drugs from yet another person who he would then bring back to take into himself and or distribute with the Hillards. And so I think it is that agreement is sufficient for the conspiracy here, because the agreement was with her and Scotty to get those drugs from yet another person.
That is an agreement to have someone other than Ms. Hillard distribute. Does it have to be an agreement as charged here that Ms. Hillard distribute?
As charged here and as instructed, it was that the defendant agreed with others to commit or assist in the commission of distribution. So Ms. Hillard herself, she participated. The charge is the conspiracy. It's her agreement with those others for them to distribute.
That puts any purchase, as I understand your argument, that would put any purchaser liable for distribution?
I don't think so. Because again, what we have here is her agreement with another to purchase the drugs from yet someone else. We've involved yet another party, another layer here as part of this conspiracy.
Any middleman, any purchase made through a middleman is a conspiracy to distribute a drug.
Okay. As for the middleman himself, like Mr. Goodpaster here, probably not. That would just be purchasing. But as for Miss Hillard, who just came up with the agreement and wanted a piece of the action, for lack of a better phrase, I think that the conspiracy to distribute is the appropriate term. And understand, I acknowledge that there's another difference here in that the distribution didn't have to occur because of the conspiracy charge. So that makes it different as well.
I agree with that. I am struggling with the idea that someone who's acquiring a drug is guilty of distributing a drug if they use a middleman, to be honest. So that, as I understand the district court's reasoning was that there was evidence that they were going to break up this 1 ounce of methamphetamine among themselves. Is there evidence to support the district judge's reasoning?
That would come from, I think, just their past pattern and the prior $600 drug deal that fell apart and that Heidi got cut out of, that being one of her main points of frustration, to put it mildly, with Mr. Goodpaster, that he was to then buy it and then provide it to them. I think that if I'm recalling correctly, there was also some evidence of this group not just sharing the drugs amongst themselves, but also selling. There was of course, the evidence of Scotty and Willie and Brian smoking in the truck in the driveway at the Hillard's home, smoking methamphetamine. But if I'm not mistaken, I think that there was at least some evidence of Willie and these others taking steps to either secure drugs for themselves to distribute or actually distributing them themselves. I don't know how much further down it would have gone, but I hope that answers your question.
Yes. Are there other questions?
All right, with that, I thank your honors for the additional time and for humoring our arguments this morning. With all due respect, I think that this was an atrocious crime. I think that the defendant received an incredibly fair trial, and I would simply ask that this court uphold all of her convictions and her sentences in this case.
Mr. Nelson, you reserve 2 minutes.
Yes, thank you, Your Honor. Let me back up to a few of the points, starting in issue number 1. The key, I think, here are a proffer wasn't called for, and it wouldn't have done any good because there was no explicit deal in this case with Samantha. The key is her exposure to criminal liability, and that's an unspoken expectation. That's an unspoken deal. The prosecution has an expectation that she will testify in a manner consistent with her prior statements, which implicate Ms. Hillard, and she has an expectation that she will not continue to not be charged. So I think that these are expectations, exactly what defense counsel wanted to get into, asking what are the indirect benefits that you will receive by your testimony. Those are easy, not a single charge. The jury's entitled to have her look at them and explain, yeah, I did all these things and I haven't been charged. And the defense has a right to go into it and show the jury her bias. She has a bias. Any of us would. I think Judge Wilson, you asked about her prior. Yes, she has prior. I believe my notes say a prior conviction for a false allegation of sexual assault and abduction. Those are my notes. And that her friend said she has a habit of false allegations. So the defense should have been able to get into her motives for testifying, which we contend are to keep herself out of trouble by lobbing accusations at Heidi Hillard. And she succeeded, apparently.
Well, the state said that came in, as that evidence came in. Do you disagree?
Only the distribution. They said, have you been charged for distribution? I think the next sentence is a little ambiguous. Siebert says, and your participation. I think he is still talking about her participation in the distribution. Had he thought that he could go into her criminal behavior, and it was, he would have done it.
No, I'm sorry, I wasn't clear. I was talking about the false allegations earlier. Did that come out?
Yes. Yes, it did. And I would remark that all of these lies, all of this pattern of lobbing accusations at other people to get out of problems, those instances that she did that all came into evidence. It still wasn't enough to convince this jury. Ms. Hillard was still convicted of rape and these other things based on SS's accusations. she should have been confronted with what she had to gain, which was staying out of life in prison. That's what she had to gain.
Was the witness represented by counsel?
Sorry, was he?
Was the witness represented by counsel at trial?
Oh, boy, Your Honor, there was a lot of discussion about getting her counsel. And I think at some point, maybe even during the trial, the prosecutor was going to see about that or get her counsel.
So there, kind of behind my question is sort of what you're touching on. Was there a record about why there was not why there was or was not a concern about incrimination? And does that discussion add to the record that we might need to evaluate here to look at this issue?
Well, I think so. Counsel Sievert encouraged her to be represented. At some point, I think the prosecutor was looking into getting someone there. That's about all I know. I mean,
Okay.
Was there, did the limitations include impeachment, which are common at trial for witnesses about crimes of false statements and dishonesty? Was that precluded also? I mean, you're talking about what prevented that inquiry?
I think they got full inquiry on that, Justice Rosen. I think that they were allowed to go into, instances when she had lied, her habits of lying and so forth. Yeah.
Thank you.
Yeah.
Are there other questions? Thank you to both counsel for your arguments this morning. The court will take this appeal under advisement. We will be in